Yeah. Welcome, Justice Srikrishna. Friends, welcome to this first keynote speech in Indian Data Protection Summit 2021. We are privileged to have with us the Chief Architect of most awaited act, which will protect right to privacy of the citizen of India. Yes, he is Honorable Justice retired B.S. Srikrishna and very well known to all privacy concerned people. I'll just briefly introduce him. He is born and brought up and studied in Mumbai. Justice B.S. Srikrishna started his private practice in 1967 and was designated as senior lawyer in 1987. He was appointed as additional judge of the Bombay High Court in 1990 and as a permanent judge in 1991. In 1993, he assumed charge of the Commission of Inquiry of infamous Mumbai riots. In September 2001, Honorable Justice Srikrishna was appointed as Chief Justice of the Kerala High Court and on 3rd October 2002 was appointed as a judge of the Supreme Court of India. On 21st May 2006, he retired from the Supreme Court. In August 2000, as we all know, government constituted an expert committee to study and identify key data protection issues and recommend methods to address them. The 10-member committee was headed by Mr. Srikrishna and they submitted their report in July 2018. The journey of bill thereafter is known to all of us. Friends, it is said that the art of conversation lies in listening. So let's take first step towards the conversation by welcoming Justice B.S. Srikrishna to share his views about right to privacy through data protection.
Thank you.
Welcome, sir.
Thank you very much. Thank you, Mr. Vijay Kumar. Thank you, Mr. Limaye. And my greetings. Good evening to everybody who is on this program. Now, we are at a stage when I personally think I'll be shooting in the air because I don't know what the face of the law is going to be, what the contours of the law is going to be. But I do know what the committee had recommended, both in terms of the report and in terms of the draft bill. Now, I was telling someone yesterday that there is a famous adage in Sanskrit which says, Vinayakam prakurvano rachayamasama vanaram. That means somebody went down to make some Ganpati and ultimately it turned out that it was a monkey. I only hope that we are not going to get a monkey out of the bill that is pending before the APC and will ultimately be passed by Parliament with I don't know what kind of amendments. Anyway, this is future. Whatever future holds, I don't know. All of you can be witnesses to that. Basically, I will talk about generally what the concept has been. The concept, people think that this is an imported concept, Western concept. For heaven's sake, forget it. They have already said in way back, in the time of the Puranas, the famous Vishnu Gupta's advice in Hitopadesha to the princes of the king. What was his advice? Ayurvittam krihachidram mantram aushadha maithune danam manapamanocha navagopyani gopayat. He says 9 things have to be kept private, privacy might be maintained. What are the 9 things? Never disclose your age. Of course, today we do it only with regard to ladies. That it was a general rule for everybody, all men and women. Never disclose the age, keep it private. Don't disclose your bank balance. Don't disclose your material possessions, your wealth. Grihachidram, no domestic problems, don't talk about it in public, keep it private. Don't talk about your sexual affairs, keep it private. Don't talk about what you've given in charity, what people have said bad things about you, what good things they have said about you. Now, he says 9 of these things must be kept private. Now, this, later on, what happened is, Some of them were kept private, some of them were not kept private. Therefore, things kept on changing. Now, a long jump from Vishnu Gupta's time to the modern day. The first time the question of privacy and right to privacy arose in India was when the high courts were called upon to decide surveillance issues. So some of the people who were surveyed and put under surveillance for no bad good reason challenge it on the ground that it is my right of privacy which is being violated. Now, there was no clear-cut concept in those days. So the court said, yes, it is the wrong thing. Therefore, we will agree that there is a right of privacy which has been violated and granted compensation. Then we had cases where, hospitals leaked out the private records of patients. There also the high courts have said that this is amount to a violation of right of privacy. Then we had, a famous case, I think from most probably from Madras High Court, if I remember rightly, where a prospective girl's father was given some private information about the prospective groom, and that became a big issue. Now, at that time, nobody thought of it as a fundamental right. Now, when then the issue arose whether it was a fundamental right or not. The high courts took different views, and there was conflicting opinion. There was no unanimity on the opinion of the high courts on the nature of the right of privacy, although vague contours were developed. The whole thing came to the fore as a result of one peculiar thing that the government of India did. And with great respect to the government of India and the people heading the government of India, they're always in the habit of shooting first and then asking questions, or putting the cart before the horse. What did they do? They came out with this concept of Aadhaar. Yes, it's a good concept. Everywhere in the world it is done. Then issues arose as to whether Aadhaar Act, of course, initially Aadhaar was not even subject to parliamentary enactment. It was only a departmental activity. Then they passed an act. The question is, does Aadhaar violate anybody's right of privacy? Now, when the issue was taken up before the Supreme Court, one of the questions, or rather one of the petition, the famous judgment of Justice Puttaswamy versus Union of India and UIDIA. Now, one of the issues raised was, hey, this is my fundamental right, so how can you take it away? Then everybody sat around and looked around and said, is it a fundamental right? Conflicting judgments were produced, and therefore you have to have a large judicial bench which would go into this issue to reconcile all the conflicting judgments. Finally, the Supreme Court, of course, I'm jumping a little, came to the conclusion that it was a fundamental right emanating from Article 21. Before that, I must interject and point out, why did I come into the picture? When the matter was being argued, one of the judges asked a simple question and said, hey, but what is the right we got to privacy right in this country? So everybody looked around, counsel hemmed and hard and said, sir, there is no real act at all. There is no real law governing the issue. Then Supreme Court said, if there is no real governing the issue, then how are you going to solve the problem? So on a Friday evening, I was about to leave for New York, and I got a frantic call from the law minister saying that on Monday morning or Tuesday morning, I have to tell the Supreme Court as to what is the legal situation. So we are going to constitute a committee to go into this question. Please head the committee. So I agreed, and then it left us history. Now, ultimately, after struggling for about 16 months, looking at the law all over the world, wherever it was necessary, we came out with a report and a draft bill. Now, the only issue that arises is, this is most important. Supreme Court finally said in Puttaswamy's case and said, hey, look, this right of privacy is as much a right to life or as much arising out of a right of life as Article 21, which is protected by Article 21 of the Constitution of India. Now, please note, Article 21 is one of the most sacrosanct articles in the Constitution. Because if you don't have life, what is the use of Article 19G? 19G will give you all kinds of freedom, press freedom and freedom of speech, and then freedom to carry on a profession and location and all that. That has no meaning if you have no right to life. Now, right to life, for example, I cannot be imprisoned without a due procedure being followed. And that due procedure has been interpreted subsequently in Maneka Gandhi's case as saying that the due procedure should be reasonable, humane, and also consistent with the other fundamental rights. So you cannot have, otherwise people will say, hey, there are countries where stones are thrown and people are, a convict is killed. I can't do that in this country because that would not be constitutional. Now, if Article 21 is sacrosanct, please note right to liberty, how it has been protected. Despite the fact that the right to liberty has been a fundamental right, there is a specific provision in the Constitution for preventive detention, but subjected to severe restrictions by constitutional provisions. So these are the manner in which fundamental rights of arising out of Article 21 has been looked at and protected. Now we come to right of privacy. If it's a fundamental right, what needs to be done? Now, this law, as and when it is passed, will apply across the board to all the government departments, government agencies, public corporations, and private entities, as well as private corporations. What are the law? The law basically is that you will keep in safe custody whatever is the data that is given to you, which personal data that is given to you for specific purposes. Now, one more interesting note. All over the world, they called they called the person whose data is taken as the data subject. So during the meetings, I raised an important issue and said, hey, why do I call him a data subject? I ceased to be a subject of the great Queen of England from 1947. So why should I call myself a subject at all? I'm a democratic citizen of a democratic country. So, and if it is my data that you are taking, why should I be called a subject? I'm the one who is giving you. And therefore, we change the terminology to data principal and data fiduciary. Now, the data principal is the person whose data is taken for specific purposes. Now, and this is the interesting thing. Data is sometimes even unwittingly given. Now, take for example, you enter the airport, so your photograph is taken somewhere. You enter a hotel or a mall or a cinema theater. There is a photograph security purposes. You take photo is taken. That is my data, and I have not really given consent. So the fundamental principle on which data privacy works is nobody can take my data without my consent. That is the basic norm. Now, there may be exceptional cases where it is possible, and those exceptional cases were recognized as, in a situation where it's a question of life or death. Let's say somebody is hit in an accident and then he has to be treated in a hotel, and there is in a hospital, and there is necessity to transmit the data to an expert doctor. Now, in such a situation, consent is not possible, definitely, but consent can be presumed. Or take the previous application, the situation that I enumerated. Namely, if I'm entering a shopping mall, I'm presumed to have consented to this data of mine being taken in the form of a picture of mine for security purposes. Now, what does the law really require? Law requires that processing of personal data which is collected, shared, disclosed, or otherwise processed in India should be controlled by this law. And there can also be processing data by the state, because the state also keeps on collecting for everything. For example, you apply for a driving license, hundreds of questions are asked, you have to answer. You apply for a passport, hundreds of questions are there, hundreds of documents are to be submitted. You go to a bank to open a bank account, he asks you 100 questions, say, get me Aadhaar card, get me PAN card, get me this, that, and the other. You go to a simple thing like getting a mobile SIM card, the same questions are repeated ad infinitum. Now, what happens to all this is today unknown. Now, in fact, I might give an example. I was traveling to Chennai. That is, I had to give information to the airplane company, and that company had sent me an email saying that your ticket is here, confirmed, etc. Then one day later, I am bombarded by emails from Chennai, here sari companies, Chennai travel companies, Chennai mithai companies, Chennai Tangamaligai and all that. Now, how did it happen? It happened because whoever took my data did not keep it under custody, protected in a manner it should have been accorded the right as a fundamental right. Therefore, it is necessary that one of the fundamental obligations is you cannot take my data without my consent. But if you want the data and I consent to it, it is on the assumption that you act like a trustee to my data. You have a fiduciary responsibility. You have to keep it for what purpose that I'm giving. Now, if I go to an airlines and give in the data, that is intended for me to purchase the airline ticket. That is not intended to be publicized to the rest of the world for their business purposes. Further, you have interesting question of how long can be this data there and how is the data to be maintained. The fundamental obligation of the data fiduciary is to ensure that the data is protected against leak, protected against unauthorized access, and protected against corruption while being kept in its custody. Its integrity must be maintained. Now, all these are the obligations. Now, these obligations should apply across the board, whether the data is collected by a state department or by an individual or by a private entity. Now, next question that has arisen is, what happens to the data when it is to be transferred out of the country? That has been a big controversy on which there has been a big push and pull between the government of India and the government of United States particularly. We had suggested, and the reason I'll give you in shortly, that whatever data is generated, personal data. Right now, please note, I'm talking of personal data because that is the thing that is before the JPC. That is the thing that we are all awaiting very anxiously. Personal data generated in India should be kept anywhere, maybe kept anywhere on a server across the border in any other country, but a live copy of that should be preserved in India. Please note the reason. The reason is very simple. Now, let's say, take an American company or a French company or a European company. They will have the data that is generated in India. Now, take, for example, your credit card companies. A whole lot of data is generated, and that is kept on a server elsewhere across the border in some other foreign countries. In such a situation, particularly in a country like America, the local law would require the authorities to disclose it to the government. Now, the American laws are very strict about it. And if somebody, the Indian government wants to access that, let's say, I am a terrorist, and the government of India has legitimate reasons to believe that I'm a terrorist, I'm doing some terrorist financing. So they want my personal record with regard to financial data accessed. Now, if it is all kept abroad in Timbuktu or wherever else, now that country will say, I will not give it to you unless you follow the proper procedure. What is the proper procedure? That mutual legal assistance treaty, which on an estimate takes anywhere between 18 to 24 months. You have a complicated procedure by which you get it. Sometimes you need the data then and there to prevent access, prevent criminal activity, prevent terrorist activity, prevent military success being sent out. In such a situation, this would be hopeless. It would not work at all. Therefore, we had suggested, hey, keep the data exactly live data updated on here, a copy, keep wherever you want. That way, everything can be done. The other alternative suggested what? Whoever is the person who collects data in India should give an undertaking that if upon a proper application being made by the appropriate authority, the data should be produced within 24 hours because after all, it is electronic data, it can always be brought. Now, that was not agreed and there were a lot of pressure brought on the Indian government. But interestingly, two things happened. Two of our regulators jumped the gun. Even before the law became operative, Reserve Bank issued a directive and said all financial data pertaining to Indian transactions should always be kept on a server here. That's what happened with all the credit card companies. They even blocked their credit card companies' operations because of that. Then the other regulator is TRAI. TRAI said all mobile data shall be kept nowhere except in India. So this became a big issue, and that is called a data localization issue. Now, please note that this is not such a simple issue, because there is an interesting judgment of the European Court with regard to called the Schrems judgment. Schrems judgment. The Schrems judgment is a very interesting judgment. What happened is, with regard to a number of European, American companies who were doing business in Europe, there was some kind of what they called a data shield agreement. Under the agreement, they had agreed that the data will be transferred across the Atlantic Sea without any difficulty, back and forth. Somebody challenged it. In fact, I think it was the commissioner who challenged it, data commissioner of one of the member countries, and said, hey, look, in America, there is a provision that the federal government can exercise power at the instance of the President of the United States and have free access to the data. That is not permissible at all. Therefore, my data is never protected. The European Court agreed with this and said this data shield is not acceptable at all. It is invalid unless several stringent conditions are followed. Now, turn our attention to what is happening in India. We had suggested that when it comes to access of personal data by state authorities, it is necessary. The Supreme Court pointed out that the state wants to access without consent the citizens' data in order to protect the interest of all the citizens. For example, criminal investigation, terrorist activity investigation, military security operations. These are all areas where data might have to be accessed by the state authorities for good reason. We said, okay, you want to do it, we don't dispute that. Only thing is this, please remember that this is a fundamental right. The Supreme Court laid down a triple test. The Supreme Court said, no fundamental right can be taken away by some Babu sitting in Delhi or Karnataka or Bangalore or somewhere and passing an order. It has to be accessed only under a parliamentary enactment, because it is central enactment. Number one. Number two, that the enactment must declare why it wants the data to be accessed without consent. And there must be a rational connection between the object declared and the methodology by which it is being accessed. Then the third one was that, what they call the doctrine of proportionality, that you will ask only thus far and no further. I always give an example and say, if you want to cut a fruit, use a small knife. You don't bring a battle axe and cut a fruit, or you don't use an atom bomb to swat a fly. Therefore, the law has to be proportional to what is sought to be achieved, the objective sought to be achieved. Now, if you do all this, then of course there is no difficulty about constitutionality. Now, of course, there is no law as that. The draft bill of 2019 was something surprising to me, because it virtually gave them a carte blanche on all the ground. And now I was reading in the newspaper that before the JPC, every government or agency is going and says, whatever happens, keep us out of it. Keep the total exemption. Total exemption is ridiculous. That means that don't make me subject to the act at all. What does it do? I have a fundamental right, and somebody who is not subjected to any restrictions can take away my fundamental right without complying with any mandatory requirements of the Constitution and safeguards. That is a situation which is alarming, and therefore, from a public platform, I did make a statement and say, if such a law ever comes into being, we'll all slide into an Orwellian state where the big brother will be able to snoop all our activities without any let or hindrance. So that is one of my objections to one of my concerns really with regard to what is happening in the 2019 bill. Then there are two, three other things. We had suggested that there should be a data protection authority, like a regulator for data protection. And that data protection authority should be established within a period of 6 months of the date notified for the coming into force of the act. And in that 6 months, he will have continuous dialogues with the various sectors with whom he has to deal, and understand and ascertain their best practices, what they call the best industry practices with regard to data protection. And by a dialogue, figure out what should be the regulations applicable to these particular sectors. Because, the data protection requirements, say, for example, in a shoe manufacturing industry, may be slightly different from an office where only some other type of activity is carried on, or some other. For example, the health industry requires greater data protection as compared to any other manufacturing activity. Now, unfortunately, the Act does not definitely say when the Act is going to be operative. It only says the Act will come into force on such date as the government may notify. So what happens if the government doesn't notify it for the next 15 years? Then all of us, including Mr. Vijay Shankar, will be waiting for it, nothing happens. Therefore, there should be a definite date by which it has to operate. Otherwise, we also said that if it is difficult to bring the entire Act into operation by one go, follow the model of the Companies Act 2013. What did they do? They said these sections will be operating from this date, these sections this, and it took almost a span of 4 or 5 years before the entire Companies Act was made operate. So that can also be followed. All right. Then I talked about localization, and I've also talked about access to the new bill has a very sneaky provision. I call it sneaky, I call it ledger domain, I call it ledger domain. Ledger domain is pickpocket. What did they do? The Act is intended to be a Personal Data Protection Act. So they introduced one section, and somewhere at the fag end, I think 97 or something like that, which says the government will have access to non-personal data under certain circumstances if it thinks that it is necessary for the purpose of the public good or something else. Now, I don't understand this. Either you talk of personal data, see, the point is this. Supreme Court has not granted or not even declared that non-personal data is a fundamental right. So personal data is a fundamental right. Non-personal data does not have this higher protection. So if it is a situation, and I can even envisage a situation when there can be a complete mixture of personal data and non-personal data. So in such a situation, how does one separate the constitutionally protected data privacy right from the constitutionally not protected or unprotected data privacy right? That is an issue that will definitely confront the courts and the citizens and enlightened members of the FD, PPI, who are all professionals in this field. How are you going to solve this riddle? That is going to be one more riddle. Then there is also a provision in the bill of 2019, which in my view is an attempt to control the intermediaries. Intermediaries is very, very in an indirect fashion, there is a sort of a control on that. That may also will have to be challenged. Now, when you come to non-personal data also, there can be 2-3 types of non-personal data. Non-personal data can be something that the government has generated. For example, the government has a lot of data on the land available, on the kind of constructions that are available on lands at different states, or with regard to agricultural activities in different areas, or with regard to weather patterns, with regard to cyclone, whatever the nature's activities. Now, on that, everybody has a right. It is nobody's private right, so there is no question of taking consent. But there could be some data that is generated by a private company with regard to its own affairs. Now, that is certainly a data which the private company has. So, now, this is, I'm not talking of personal data. Please note, personal data is a separate kettle of tea. Personal data, for example, in a private company would be the personal data of all the incumbents, of all the employees, of all the persons who are dealing with it as customers, etc. Apart from that, a company may have, the board may discuss a whole lot of stuff. Like what? Like how are we going to raise finances for the next 10 years? How are we going to source material, raw material for the next finance? What is going to be our strategy for persons who are going to retire? What is going to be our strategy for inheritance of the power in the company? Now, these are not personal data in the strict sense. They are non-personal data. But why should the government have access to this? Now, if I'm running a company and I'm saying this is the manner in which I'm going to get finance, why on earth should a big brother have an access to this without my consent? So this is one of the fundamental objections that needs to be carefully looked at and at an appropriate stage raised before somebody who understands it and somebody who's is willing to take a call on that. Then issues like data protection authority. Now, a data protection authority is by definition a regulator. Now, a regulator is again by definition a person who is not a government stooge. Please understand this. A regulator is an independent person, like say the election commission and even take a judge. A judge deals with laws, deals with parties, deals with controversies, but he is independent. He is not going to, of course, if he toes the government line, you know what he is. He is not a judge, honestly, a judge. He is not supposed to be. Similarly, a regulator, although I wouldn't elevate him to the level of independence of a judge, would say, has to take an independent view based on whatever is the circumstances. Now, therefore, we had suggested that the Data Protection Authority, please note the importance is this, should comprise of not less than 50% of independent practitioners who could be professionals from data protection, lawyers, academics, both from India and abroad, who understand the subject, with a chairperson as some judge sitting or pastor or whatever, plus some government nominees, but the majority being non-government nominees. Now take a look at the composition of the Data Protection Authority in the 2019 bill, which is likely to be passed anytime now. Every one of them is a government nominee. So it is virtually saying the government is sitting in the Data Protection Authority and dictating to you what should be done. The Data Protection Authority has several responsibilities. One, of monitoring the data protection in all the units that are within its jurisdiction. Now, one of the questions that has been posed to me always is, how can in a country like India, somebody sitting one get corner control the whole thing? That is an absurd question according to me. If the law can be, I gave 2-3 examples. So for example, Provident Fund Act is a central act. There is a central Provident Fund Commissioner sitting in Delhi. But every state has this act. And there are even local areas where this act is enforced. Because Provident Fund Acts beyond a particular threshold of number of employees, you have to compulsory deposit. State Insurance Act, Employee State Insurance Act. Then you have Factories Act. Factories Act is again a central act. You don't enforce them. Income Tax Act. I would be happy if Income Tax Act is not enforced in my own state because of the difficulties in enforcement. The difficulty in enforcement is a ridiculous argument. If the government wants to bring a law, then you can certainly have representatives of the government dealing with this. So there can be a central data protection authority with maybe regional data protection authorities or whatever you call them, whatever appellation you give to them, who will be responsible for the protection of data within their jurisdiction. This can certainly be done. Therefore, it is not a big deal to say that it cannot be done. One more point that comes to my mind is this point about consent. Consent, in order to be, we have said that consent is the basic requirement. Therefore, merely because you have taken consent, can you do anything else with the data that you have taken? No, you cannot. There are restrictions called the purpose limitation and the time limitation. Now, if I give my data to somebody for purchasing the X commodity, that is a purpose limitation. He cannot use it for anything other than that. Or take, for example, I open a bank account today, and 3 months down the line, I find that the bank is not very satisfactorily giving me service. Why should I not close the thing and say, drop all my, or take your Facebook account. I can close it anytime and say, I don't want any of my data to be kept with you. Either delete it or satisfy me that you're deleted or return it to me. Now, only problem with regard to the bank illustration is that there may be another law which requires him to maintain that the bank manager will say, sir, but for income tax purposes, I have to keep the accounts alive, records alive for 7 months, 7 years, because that is the law in the country. Fair enough. If the law warrants it, keep it for the period that the law requires you to do it. Otherwise, this situation does not arise. At my demand, you should be able to enforce this right of deletion of the data. Then I should also have, as a data principle, the right to call upon the person holding my data to show me whether he has held the data, ascertain whether it is correctly held, that the integrity has been maintained, and call upon him to rectify the data if it is not properly held. One question that arises is, how do we, in a country like India, how do we get consent from people? I don't know how many of you remember when the mutual funds used to have advertisements on TVs. It used to be some garbled blah, 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 and then it was over. Till SEBI came down on them and said, the advertisement should run for a minimum period. It should be clearly articulated so that people can understand it. Because consent always must be informed consent. The person who gives you consent must understand the pros and cons of what he is doing. And then if he gives consent, that consent is valid. Now, in a country like India, where there are, I don't know what is the last count, 26 languages, 24 languages, whatever the number of languages, plus any number of dialects, sub-dialects, people not even being able to read or write, how are you going to get their consent? So we had said, okay, that may be a problem. But now if you have, say signboards, traffic boards, some of them are graphic. So if you have, for example, poison, when you say the poison in a bottle, you show the skull and crossbones and saying this cannot be done, or cigarette with a cross saying that it cannot be done. Something like that can be evolved. That is where the ingenuity of the Data Protection Authority comes in. Now, this ingenuity can only come in from person who are qualified, person who understand it, and who are interested in solving the problem. So that is not, and if there are 22 languages, go ahead and each state. Now, how is it that in Bengaluru, all the buses carry Kannada advertisements? And if I don't know Kannada, am I not in a position to carry on transaction here? This is possible. It is not very difficult. Now, all the signboards are supposed to be in Kannada here. In the name has been changed to Bengaluru from Bangalore. Now, if you can do that, Data Protection Authority can certainly look into it and carry out this exercise. Then one more question with regard to consent is, there is what is known as the consent fatigue. Now, if I have hundreds of things where I'm asked to give consent, I might get fed up and say, most of us do it right now also. Because when you open a website and you want to log into it, there will be some, or take for example, the iPhone. There will be a 20 pages agreement which you have to see. I have no time to do all that. I go to the last page and click and say, I agree. Now, if that can happen to me, who is supposed to have been a judge of the Supreme Court, I can understand what an ordinary citizen, he has no time to do all this. So if there will be, and if you ask consent from 20 people, there will be consent fatigue. Now to that, the answer given is very simple. There is what is known as a consent trust. Now this has worked beautifully in England particularly. What they do is, they are like, persons who hold your, if I am a busy person, I don't have time to go around dealing with all my bank affairs. So what can I do? I can't go to the sub-registrar's office for buying some property. What do? I give a power of attorney to a person in whom I have trust, and I tell him that whatever you sign is signature on my parcel. So if you can have that in all financial and other transactions, why can't you do it with regard to consent also? So that consent trust is something like giving my bank manager or somebody authority to carry a transaction on my behalf. So consent is also not such a difficult area to deal with. Now, these are some of the aspects of the data protection law that I thought I would highlight, because I'm really, as I said, at a handicap, because I don't know what the law is. I know what the law was recommended to be, and I'm assuming that that is going to be the law. If that is not going to be the law, then I'll have to certainly come back to you and again talk to you about what the law is. Now, till that time, I suppose these remarks should be held as an interim remark from me, and as and when the law is enacted, or depending on what the JPC does and what the Parliament does, and all these superfine amendments that they're going to bring in, we shall see what happens. And as we say in Kannada, Mundinadannu pardeya mere nodi. That's all that I can say. Thank you very much. I'm willing to answer any questions for the next 15 minutes, if there are any questions.
Yeah. Good evening, sir. First of all, quite interesting and very impressive. In a nutshell, thank you very much once again. A few of the questions where our members had asked, I'm just putting it in. I consolidated it. I'll ask you. I'll start with the question. I really liked it. Kind of lighter side. Is asking. Just a minute, dear sir. Do eminent people like yourself also get unsolicited commercial calls / text messages? How do you manage them? This is from one Mr. Namit. Yeah.
Okay. I have an iPhone. Every day
Yes,
in the morning, I get up at 5:30. And what do I do? 30 to 40 unwanted emails I have to delete. Otherwise, somebody, Vijay Shankar writes an email that gets lost somewhere. I can't access it. First thing I do is, like flushing out my toilet, I flush out all this. Now I get it. I assure you that I'm not exempted from this malaise.
Quite interesting. Great, sir. Thank you very much. And other questions I will quickly. Mr. Jayachandran is putting a question. What's the rationale behind defining only certain data elements as sensitive personal data? It is highly subjective in a country like India. Will it be dynamically changing by subsequent amendments? Yeah.
See, it can always be changed. For example, that is why I told you, what are the
Yes,
things that were considered sacrosanct in this country. Now, age at one time was, in fact, my grandfather was 95 when he died. But anybody asked him, what is your age? I don't know, it might be 60 plus something. He never said 95 to my knowledge. That is because he believed in that Vishnu Sharma's mandate. The Ayurvedic. Yeah. And if somebody asks me, what is your wealth? Even today, I will say, 100 rupees here or 100 rupees there, nothing more than that. Or at the most, I may say, I am a retired poor pensioner. The government of India gives me so much pension. Why should I disclose them to all my wealth? So these are the things that must be kept confidential. Now, the point is, the concept of sensitive data is something different. Now, for example, if somebody asks me and says, what's your name? I say, my name is so-and-so. That is my data actually. I don't consider it sensitive. Or somebody asks and says, sir, how tall are you? I say, I am 5 feet 9 inches. There's nothing sensitive about it. If you ask me what is your weight, that also I'm willing to disclose because I don't think I'm not too fat there, I'm not worried about it. But if you were to go to a lady and ask her, oh, what is your age? She'll slap you. And
right.
You're lucky if you don't get slapped because that is offensive, considered offensive. Why? Because that is super sensitive for a lady. Similarly, financial data is considered sensitive in some areas and not very sensitive. But if you ask me my health data, saying what are your health problems and all that, I will say it is much sensitive. Why should I tell you? Except, of course, please note, when I'm dealing with an insurance company and I have to take an insurance policy, I have to make this disclosure, whether I got diabetes, whether I got blood pressure, whether I got asthma, whether I suffered from any other diseases, whether I had surgery or this, that, and the other. Or you are going to insure a car, you have to give them a whole lot of data which you would not otherwise. Therefore, sensitivity is a matter of, let's say, cultural imprint also. Because if you are in America or in any Western countries, they'll freely discuss everything. They will not discuss about your salary, but your sexual affairs are all freely discussed. In India, it's the converse. The first thing they ask you is,
yes, sir.
Therefore,
definitely.
Sensitivity is a matter of cultural background. So depending on that, it's possible to add or detract from the list. It is just a question of amendment, that's all.
Great. Thank you very much, sir. Next question is from Mr. Mohammed. how far the data localization policy is effective on social media platforms?
I don't know. See, first of all, this concept about data localization was intended for a different purpose. No, I don't think they've made it applicable to social media platforms. No, they were intended to be with regard to personal data. Now, you are right. If personal data can also be held by a social media platform.
Yeah.
It may be possible to apply it and say, hey, if you are going to hold it here, or hold only a copy, because let's say you are dealing with an entity like Facebook or whatever that, Instagram or something like that.
Yeah, yeah.
Now, there are very conceptually there are difficulties which are created by them. Therefore, an investigation may be necessary. And when the investigation is done, if the social media chap tells you, sir, I can't help you because all my data is in America or in England or Germany or France, that is not going to solve the problem. Therefore, it is necessary, like any other data, you'll have to have this kind of a restriction on that also.
Great, sir. Great, sir. Thank you very much. And question from Mr. Navi, sir, that publicly available data and the related privacy issues. Publicly available data. Yeah.
Yeah, let me tell you, this question is answered by the law in another department, namely breach of confidence. Every contract has a breach of confidence thing. Please note, one clause will always be this contractual protection will not apply to any data that is already published. See, if you're publicly made available, you can't claim privacy over that.
Right.
Because what are you doing? You know full well that it is going to be accessed by somebody without your consent, and yet you're putting it. Therefore, one can say that there is an implied consent granted to that. Now, if you are going to change your clothes, you better draw the curtain. If you keep the curtain open, you can't help the person outside standing and seeing you. Therefore, that is how I would say, if you're putting in public, then we can't be a private. These also why law of defamation also has this kind of an exception.
Great, sir. Great. Really, that examples what you're quoting, great. Next question is very quickly. Section 42 of the bill says the committee of the secretaries will identify the DPA members having specialization on data security, PII security experience of 10 years. As on date, what is the scope of finding such 7 persons to form the DPA?
So all
is
of
from Mr. Adupu.
Let me assure you, this means all of them will be government nominees, nothing else. There will be absolutely government nominees, because the secretary is not going to identify me as a member. They know that I'm not bad man.
Right.
They will not identify Vijay Shankar because they know that he's a competent man. They will not identify you because they know you're a professional man. So they will identify somebody. And so see, the point is, this identification by a company, by a group of directorates, is not a guarantee that the man really is worth what he is. If it was, then our country would be a great country. I don't think that is going to result in the DPA being captured by government nominees. That's all. That is my last word on that.
Okay. One more question I will pick up, sir. How do we balance big data used by the corporations and competition laws, as it also makes some companies control all the data or become master sellers for the people's data?
You see, this is an issue that
Yes,
I've already been asked once and I've answered it. Now you have these companies. One company has a lot of data. Another company is interested in, I will not take names of the companies, it's not fair.
Sure.
Interested in having a retail business. Then they merge. The question is, this could be a matter of investigation by the CC, the Competition Commission. Because what are they doing? They may dominate the market and they may distort the market itself by their operations.
Right.
Now, whether by itself it amounts to an infringement of the data protection law, it is not possible to answer, because the Data Protection Act is not going to talk about this. If they did, it's not necessary according to me, because competition law is a law by itself, sui generis. Now, whether it is in data protection or raising finance or raising raw materials or just plain competition amongst manufacturing companies, CCA looks at it from a different point of view. Therefore, it is not possible to stipulate that automatically it will come into within the purview of CCA. But if it does, then they should investigate and take action according to the Competition Act.
Great, sir. Thank you very much. I will go with the last question, sir. I understand your time. This question is, how can the government be convinced that this policy bill should be getting passed at the earliest? According to you, what data principles can do to compel government to pass the bill in for protection of their fundamental rights?
No. Well, data principles cannot compel the government. Let me tell you, the government cannot be compelled. Sure. Government, look, wouldn't you compel the government to do anything? You can't do it. First of all,
right.
You even by a writ petition, you cannot compel the government to bring the act, because legislation is totally out of purview of the jurisdiction also. So all that you can do is, how do you, let me ask you, tell me, how do you, let me ask a counter question, whoever asked me the question, how do you make God give you good things in life?
Only I can pray. Very simple.
Of course. People
yes, sir.
Pray and say, please do it, it's good for us. And intelligent people like you can bombard your opinion on them, debate like this and say that this is what should be done. Or if nothing else, farmers in Punjab, you can go on a protest. But I don't think you're going to do that for data protection.
Excellent. Great. I understand. Great. I think we have covered, sir. Only one last question, if I can take your time, because this question, thanks, sir. Just a minute. This will be the last question by Mr. Subrayadu. By allowing companies to take the data of Indian citizens outside India, even if the copy of the data is going to be maintained in India, is it not akin to allowing an oil drilling company to extract the oil from the foreign country and remit the extracted oil to its home country without paying a royalty to the place from where the resource was originally located? Did India miss its oil discovery-led economic transformation moment by allowing the transfer? Yes, sir.
This question is asked on the assumption that data is oil. Please understand, people have a wrong what data is. Now, somebody said in America or in England somewhere, and said data is the new oil. So everybody is remouthing it, and data is the new oil, and this example is data is an oil. Let me tell you, data is not oil. Data is not material. Example, why do I say this? Now, if I say that this iPhone is my property, right?
Yes, sir.
What can I do with you? I can present it to Mr. Vijay Kumar. I can lease it to you. I can lease it to Mr. Kauta. I can sell it to him. And if I don't like it, I can even destroy it. Nobody can ask me any question. It's my property. Right. So when you say the genitive case, it has two concepts. One is ownership. Now, if I say this is my wife and my daughter or my son, the concept is not ownership. Mind if I talk to my wife and said, I am your owner, she'll slap me. Any right thinking woman will do that, because women are not properties. Therefore, what is this my there? When I say this is my hand, what is the concept that I'm using? An intimate connection between me and that. Just like I said, my hand is my data. Now, for example, take a simple illustration. My name is my data. Nobody can access it. Now, if it is like my oil, I could have given it to you for lease. And sir, 6 months they use my sir, parvagilla. I can't do that. Therefore, this is the next meeting. Hello.
Okay.
I'm about to. Where are you? Yeah, in another 5 minutes it should be over. Just give me another 10 minutes, okay? Oh. Okay. Okay. 1645. Yeah. Oh, okay. Thank you. Sorry. So, data, the relationship between the individual and the data is a matter of intimate connection and not proprietary relationship. So say Therefore, my maintaining the data elsewhere doesn't amount to like the oil being dug up from the earth in India and sent abroad.
Right.
Because it is just that. The moment you think of data in terms of material object, you get confused and you come out with this kind of analogies.
Okay. Okay, great, sir. Thank you very much once again for all your answers. Really, it was a very excellent and inspiring session for all of us. Thank you. Yes, Mr. Navi, sir. Sir, you are on mute, Navi, sir.
Sir, thank you very much for your excellent explanation of various things. Anyway, there will be a formal vote of thanks, but before that, extending one of the questions which was said, how to find out the right persons for DPA. Last year, we announced in our IDPS that we will have an award for somebody who may be called a data protection champion. Basically, identify somebody in India who can be perhaps who deserves FDPPI to some kind of say recognize that person. So we instituted an award for data protection champion. And what we did was we didn't want to actually ask public to either nominate somebody or ask some person to nominate himself. Somehow I find that the best person will not nominate himself for any award, though that is a normal system in many other these things. So we went about having a small search committee and tried to do our best to find out somebody. The idea was by choosing somebody, we should be able to give some kind of an inspiration to others. So with that in mind, we instituted this award, and Ramesh Kauta was the chairman of that committee. I would request Mr. Ramesh to please announce the person whom we have perhaps identified, and then I will invite that person also to come on stage, and we'll formally, just for a couple of minutes we'll take, sir. In your presence, if we do it, it is an honor for him as well.
Go ahead, no problem.
Yeah, Ramesh. Yeah.
Thank you, sir.
Yeah.
This is Srikrishna, sir, and panelists and participants. Good evening. And first of all, I would like to thank the Navi and team for conducting this great session and bringing the experts in to talk about it. And I have the privilege now to announce the first data champion of India. So now I have got the cover. I don't know how Navi sir managed to get me at the right time. So I have the cover in my hand. So I'll be opening it and then finding out the name along with you. Definitely, I hope this will be an excitement for all of us to go ahead. I'm opening it now. And I'm also eagerly waiting to see the name here. Oh, okay. So I'm sure this name basically will not surprise many of you. And without any much surprise, I'll announce the name. It's Srinivas Pusarla.
Oh, very good. He is well-deserving candidate. I happen to have interacted with him on one of the previous webinars, in which all kinds of people from abroad were also there.
Yeah, and it definitely is my privilege to announce this. Congratulations, Mr. Srinivas. I think it's a privilege. If you can come on video, it will be helpful. Sir, I'll take a couple of minutes to read out the citation. It will not take much time. Mr. Srinivas Pusarla, currently the Senior Vice President, Chief Privacy Officer and DPO worldwide, is responsible for Infosys compliance to data protection regulations in over 40 countries, including driving privacy by design initiatives for Infosys digital application and solutions. He's a BTech from the Indian Institute of Technology, BHU, and thereafter completed the extensive global leadership program at Stanford University, Graduate School of Business, and PG Diploma in Cyber Law, Cyber Forensics from National Law College, Bangalore. In his illustrious career of over 30 years, starting with Tata Steel and then Infosys, he was associated with a diverse set of enterprise functions, including the steel manufacturing, quality, information security, and has been playing global GPO role since 11 years. Srinivas plays an active role in India Data Privacy Standards Committee, industry bodies such as NASSCOM, DSA, and as an advisory group member in few government committees. He is designated expert in identity management and privacy technologies, working group of ISO SC27 committee, where he has been playing active role in development of privacy standards. He has been the co-author of ISO 27701 an extension of ISO 27001 for privacy information management systems, guidelines for privacy protection for AI systems and ML models, privacy operation model and method for engineering, and more recently, privacy preservation by ZKP, Zero Knowledge Proof. Is also an active member of BIS LITD 17 committee, as part of which he was appointed the convener of the core group of experts that developed India's data privacy standard IS 17428. Srinivas also participates in global privacy matters and is currently in the Privacy Engineering Advisory Board of IAPP. Srinivas stands out as one of the few professionals in India with demonstrated commitment for privacy and data protection over an extended period. Yes, Srinivas, we at the Foundation of Data Protection in India are extremely happy to have had the opportunity to confer the recognition to you as a data protection champion for the year 2021 during the occasion of the India Data Protection Summit 2021. We're the first recipient of this prestigious award from an organization of, by, and for the data protection professionals of India. We are honored by honoring you. Sincerely, Srinivas, it's my privilege to introduce you and to share the award with you. Congratulations, sir.
Great.
Thank you, Ramesh. Sir, can you have a couple of words about this award?
Mr. Vijay Shankar, I'll tell you what is this award. This award will have great weight if people like Srinivas are nominated by this Johnny sitting in the government committees. But this is exactly what we had said. We said a representative of the industry who understands the subject should be there. Now, what is the use of putting somebody who doesn't understand, but he happens to be a good man otherwise because of the party politics? This is precisely what happens when the government nominates people.
Yeah, that is true.
Now, if the government were to take a view that all certified data professionals will pick the best of the persons, I have no problem with that. Now, just because the government thinks that I'm an expert on data, I don't become an expert on data. This is precisely the point. I'm happy that this has come about exactly what I was saying. Worked out in principle.
It's 19 hours.
Yes, sir. Yes, sir. Yeah, Srinivas, would you like to say something?
Yeah. First of all, can I hear me, Navi?
Yeah, I can hear you.
Thank you. Thank you. There's some problem with the video. I will rejoin through another PC. Video is not getting on. So thank you, Navi and the FDPPI team. It's a great honor to get this award. It's not easy to choose one winner from the entire country, such a large country. I know we have so many data privacy professionals. And thanks to Srikrishna ji, BN Srikrishna ji, an eminent data privacy leader for us. Nothing can be better than receiving an award, such an award from an eminent person who's instrumental and drove the committee which drafted the PDP bill. So it's a great honor, sir, to receive this from you. So I think it'll, as you rightly said, this is going to be a very important for us to set the context for the country that data privacy is very important and more leaders should come forward and work towards achieving this. So I think I would add few words from my side that this I had joined this actually 11 years ago, exactly 11 years before I started this profession. And we were one of the first companies, Infosys, we started this separate niche area. And back then, I think there were not many data privacy professionals, so we kind of get into all kinds of initiatives and not many. So anything that happens in data privacy, we get an opportunity to participate in that. And that's kind of gave me drive, and then it was a natural passion for me to get into this. And I don't even understand the difference between work and personal life. When I'm doing privacy work, it's almost like work and personal life is mixed. And this would not have been possible without the support that I got from the company Infosys. It's very important because in today's world, data privacy needs that impetus and significance to be given because of the empowerment that's called for, the kind of role. And that I think the company has given, and I thank my leaders to enable, and we are one of the first companies to do that in an effective way that it reports to the board. I'm thankful to all the leaders who gave me this empowerment. And also, of course, my own team, which helped me to drive these things in my DP office, and also the family, without whose support, if they didn't accommodate, I could not have spent so much of time to make a difference like this. So this is what I would sum up to say. And then let me also say a few words about the future trend that we need to know about India in data privacy. So Navi, I would just reattempt to join through another PC. Give me just a minute.
Okay.
So that I can come on the video.
Yeah.
Just give me a minute. Thank you.
I think, yeah, Justice would like to leave. So Mr. Kauta Minala, will just thank you.
Yeah, Meena.
Yeah. Good evening, sir, and good evening, everybody. I know you are hard pressed on time. Perhaps you have another conference or a meeting lined up after this. Friends, they say gratitude and attitude are not challenges. They're really choices. Today, we all gathered here to listen to the wise words of Honorable Justice B.N. Srikrishna, former judge of the Supreme Court of India, who has been the doyen of the law relating to personal data protection. I deem it a great honor indeed and privilege to formally propose a vote of thanks to you, sir, on this memorable occasion of Indian Data Protection Summit 2021. Sir, at the outset, your grant of consent to grace the occasion, to grace the summit, served as a big booster for FDPPI members to rejig their busy schedules and make it a point to attend this evening's high point and hear from you directly your views, which all of us have otherwise been reading, either directly through your articles or your detailed works. So within the short time that you spoke to us on, you touched upon the relevance of consent, significance of data localization, judgment of ECJ on SCREMS, obligations of entities for transfer of data, purpose of limitation, etc. There were so many points in your address to us. All these are concepts which still require not only a legislation, but a host of rules and multitude of regulations apart from sectoral policies which you spoke about in the context of retention. We profusely thank you for being in our midst this evening and sharing your valuable views on the subject. It will indeed go a long way in shaping the future programs and directions of FDPPI, as you just mentioned in the context of award also. Of course, the nomenclature makes an enormous difference. So, sir, let me say this, that people who understand and are associated with the subject would always hail your innovation of coining the terminology of principles rather than data subjects. Sir, I would urge you to keep guiding us in times of dilemma, as the subject is amorphous, according to me, and yet to take feet to evolve in India.
Yeah.
We shall look forward